Thank you so much. viewed under Creating Emerging Market Project at Harvard Business School. He was the founding chairman of Business Advisory Council of United Nations SCAP and was the member of the Independent University of Bangladesh. Mr. Rahman was the president of Federation Chamber of Commerce and Industry of Bangladesh, and he was the Dhaka Chamber of Commerce and Industry, the premier chamber of the country, and he was the first vice chairman of the SAARC Chamber of Commerce and vice president of West Asia of 57 Nation Islamic Chamber of Commerce in 1993. So he is respected as the business leader, the icon of Bangladesh business community. So with these few words, I would now request our Honorable President, Mr. Mahbubur Rahman, to deliver his welcome.
Thank you, Mr. Rahman. It's been a pleasure of having all the distinguished persons of the ICC Court of Arbitration. And I've been told that it is as if they are visiting Bangladesh, but virtually. But as I said in the beginning informally, that we need to see them physically. And in that event, the impression of Bangladesh business community, and for that matter, the government of Bangladesh, will also recognize them to have more ICC arbitration there. Despite the fact we ourselves have been promoting the arbitration, ICC arbitration, I can say almost 30% or maybe even more of the government contract is having this ICC arbitration clause in all the, mostly in the construction industry. To say something formally, a very good morning, good afternoon, good evening to some of the people who are not here in Bangladesh and outside Bangladesh. A very good day to each one of you from ICC Bangladesh. As you may know, the ICC Bangladesh came into being in 1994. We are going to celebrate 30 years next year. We have already celebrated our 10th year, 20th year, and we are going to celebrate the 30th year also in the coming year, inshallah. You are all aware that ICC Court of Arbitration, which is headquarters in Paris, has been celebrating its centenary throughout the world through its national committees. ICC headquarters and national committees are arranging programs to observe this centenary celebration during 2023. Accordingly, ICC headquarters and national committees are organizing all such programs in a number of countries, and today it is the Bangladesh National Committee has organized all this. As you may perhaps know, the ICC Court of Arbitration came into being 100 years back in 1923 under the leadership of ICC Chairman and French Minister for Commerce, Hossain Clementel. If I have spelled correctly, I do not know. And founders of ICC known as Merchants of Peace. All of them were involved and instrumental in organizing this ICC Court of Arbitration, which is respected worldwide as one of the most reliable, trustworthy, and invaluable institution for resolving commercial disputes. On this occasion, ICC Bangladesh and ICC Court are having today's event virtually. A very warm welcome to all of you once again to this centenary celebration of ICC Court of Arbitration. I would like to welcome ICC Court President Claudia Salomon. Is she there? Okay, Claudia Salomon is already there. And Secretary General Alexander Fessas. Alexander Fessas. No, we cannot see her. Is she?
I'm also here. Hello. Yes.
Sir, if I may request Claudia to raise your hand so that we can, everybody knows, and Alexander also, the ICC Court Secretary General.
Okay. Then and Director ICC Arbitration and ADR, Donna Huang. By appearance, you can see that she is Donna Huang, for joining us at today's event. I would also like to express my sincere thanks to ICC Bangladesh Commission on Arbitration and ADR, Chairman Ms. Nihad Kabir. Nihad Kabir is there. তুমি তোমার ওই যে এটা একটু করে দিলে তোমার চেহারা পুরো দেখা যাবে, এটা আধা দেখা যাচ্ছে। Right. Now right. Thank you. Nihad Kabir, the barrister at law and an eminent jurist, and she is the moderator of this roundtable, which we named the Challenges and Best International Practices for Enforcement of Foreign Arbitral Award. Just to introduce her briefly, Nihad is a senior partner of Syed Ishtiaq Ahmed and Associates, a leading law firm of the country. She is an eminent, well-respected lawyer of Bangladesh. She is advocate of the Supreme Court of Bangladesh. Barrister Nihad Kabir was president of the Metropolitan Chamber of Commerce and Industry, Dhaka, which is a 114 years old Chamber of Commerce in the country, the oldest one. She is a director on the board of Square Textiles, Prague Bank, Infrastructure Development Company, and Bikash. Bikash is the mobile banking company and the largest and the most respected mobile banking in the country. She was the Secretary General of Ain o Shalish Kendra, and in Law and Arbitration Center, a legal aid institution. She is a member of the Company Law Reform Commission, fellow of the BIDS, Bangladesh Institute of Development Studies, member of the Board of Governors of the Bangladesh Public Administration Training Center, which is chaired by our Prime Minister, and has been a member of the National Pay and Services Commission, National Education Policy Committee, Government of Bangladesh, and many more. You have already seen Nihad Kabir. I also thank my colleague, friend, and a well-wisher, and a member of the ICC Executive Board, Mir Nasir Hossain. Mir Nasir Hossain is there. Bondo to. Eta bondo.
I'm here, Mr. President.
Mir Nasir Hossain is also a former president of our apex trade body, which is called the Federation of the Chambers of Commerce and Industry, and is also the managing director and the chief executive of our the leading, if not the number one, the construction company in the country. And we have also with us Samir Sattar, barrister at law, who is also currently the president of the Dhaka Chamber of Commerce and Industry, which is the premier chamber in the country. Samir Sattar. Abdullah, I'm
here. Thank you.
Thank you. And all the distinguished speakers who are with us today, including our audience who have joined virtually from home and abroad. Nam nai keno? Secretary?
Ase.
Dekhin ache. Mr. I have also with me one of my best friend, colleague, and a leading entrepreneur of the country, having his hands spread in a number of areas, including apparels, textiles, construction, housing, you name any. And very recently, one of his factory has been recognized the #1 green factory in the world. #1 green factory in the world. The Kutubuddin Ahmad is a celebrated and quite young entrepreneur that we can see who has excelled in a number of areas where he has put his hand. ICC was created in 1919, you all know, by the founding chairman and French Minister of Commerce, as incremental, and ICC founders known as the Merchants of Peace. Those who joined in creating this International Chamber of Commerce, they have named themselves as the Merchants of Peace. Because in those days, immediately after the First World War, the trade among the countries were very little, and also there are hundreds of barriers. Everyone wanted to protect their own country and protect their own trade and one economy instead of allowing it to the rest of the world. And to what is called dismantle this barrier, the ICC has been working from the day one. We must trade across the border without let or hindrance. In May 1922, the ICC Executive Committee approved the creation of an International Court of Arbitration for Commercial Dispute Resolution, and ICC Court of Arbitration was inaugurated on the 19th January 1923. It is so 100 years now. As an international dispute resolution mechanism, with all important objectives of promoting access to justice and rule of law. Bangladesh National Committee of ICC, founded in 1994, is comprised of major trade organizations of the country, the government and semi-government institutions are also the affiliates, national and transnational corporations. Since its inception, ICC Bangladesh has worked tirelessly to promote foreign trade and investment, trade policy reviews, business dialogues, organize seminars and workshops, both at home and abroad, on related policy issues, which ICC deals with. harmonization of trade laws and rules, legal reforms, and informing business about the ICC rules and standards for cross-border business transactions. You all know ICC conducts almost all rules and regulations in international trade and business. Letters of credit or international payments are also done under the laws of ICC and recognized by the United Nations and adopted worldwide. Bangladesh National Committee, as I said, has been working relentlessly in order to bring about a change in the overall perception of the international trade, and we are working almost every day. We organize training programs in cooperation with the international organizations as well as our local banks and institutions, and more particularly in this case, the LIBA, London School of Business and Finance, being our cooperators, our partners in organizing this banking training. And so far we have trained more than 1,500 experts in the banking industry, which has been contributing towards the excellence of their career at the same time for understanding the new laws and regulations which is coming up with the change of time. Since it is established, ICC Bangladesh has been promoting arbitration and ADR. The National Committee has been nominating senior legal experts of Bangladesh to be the member of the ICC Court. Former Chief Justice of Bangladesh, Justice K.M. Hossain, served as ICC Court member for 6 years. At present, former Attorney General of Bangladesh, Mr. A.F.M. Hassan Arif, is a member of the ICC Court. Many of our eminent members of the jurisprudence also served in ICC Court from time to time from the very beginning, and many of them having their credential and credits in the overall legal profession. Currently, ICC International Court of Arbitration is the most preferred arbitral institution in the world. The application of a modern, fair, and predictable law to the contract is a key component of modern supply chain management, as it allows to manage the supply chain more efficiently and to solve any dispute more quickly. In this case, if I may be allowed, Claudia, if you don't mind, I would like to mention that there is a perception, right or wrong, I don't know. The ICC court is little bureaucratic and very expensive. So for countries like Asia, South Asia, we have difficulties. So for that reason, people try to go to Singapore, Hong Kong, despite the fact that we are having their establishment in Hong Kong and Singapore also. But perception, right or wrong, I do not know, that the ICC is little expensive and the arbitration process is delayed due to the bureaucratic process. I wish it is not right. And the contracting parties in Bangladesh have not yet realized the full potential of the ICC rules of arbitration and mediation. As such, ICC Court of Arbitration and ICC Bangladesh Commission on Arbitration and ADR may take up joint program to promote ICC rules of arbitration and mediation in order for parties to adopt these rules fully to reap the benefits. Today's topic of discussion on the challenges and best international practices for enforcement of foreign arbitral awards is of vital importance for Bangladesh. Foreign direct investment is a powerful tool for economic growth, especially for a developing country like Bangladesh. The ease with foreign arbitral awards may be enforced as a direct effect on foreign direct investment, particularly in a country like Bangladesh. The existing legal framework in Bangladesh for enforcement of arbitral awards, be it foreign or local, and arbitration in general, has significant room for improvement. And ICC Bangladesh is working quite closely with the Ministry of Law to amend this the existing law so that we can overcome the situation so that the international or local arbitral awards is enforced immediately. For that reason, we are working together. And in this case, I must say, the chair of our Commission on Arbitration and ADR, she is also directly involved and working. We are working together. So at this point of time, I would not like to prolong my deliberation in this case any further. The reason being, we have limited time, and some of our friends would also like to join us, but at the same time, they have other commitments as well. And before I conclude at this time, I would also like to introduce our keynote speaker, Alexander G. Fessas. Alexander Fessas is here. I can see your picture. Do you see me? Alexander is. Now
I do see you. I hope you can see me now and hear me.
You can hear me.
I can, loud and clear.
Alexander Fessas is a director of the ICC Dispute Resolution Services. As Secretary General, he is responsible for the operational management and coordination of the ICC Court Secretariat and other dispute resolution services in Paris, Hong Kong, New York, Sao Paulo, and Singapore. He joined the Secretariat in late 2011 and held consecutive positions in 3 case management teams, of which 2 as counsel. Prior to his appointment as Secretary General, he was the Secretariat's managing counsel over a 3-year term. Prior to joining the ICC Court, he practiced as a counsel out of Athens, where he established a sole practice in 2008. He was previously an associate at an Athens-based law firm. During the same period, he was also the editor-in-chief in the review Hellenic, the Third International. I'm sorry. Excuse me. Alexander G. Fessas. I'm sorry. Excuse me for a moment. For the time being, I stop here. May I now invite Alexander to make his presentation.
Well, thank you very much. It's a great pleasure to be able to join you, albeit only virtually. I think we both Claudia and myself, heard the request, which I think our matched also with our intention to be able to join you in Bangladesh in person before too long. And the same, of course, goes for our teams in Asia, including Donna and her team, and our teams in Hong Kong and Singapore as well. So from the European side, thank you very much for organizing this event, and we're most grateful for the opportunity to interact with all of you here today. It is my privilege to welcome you on behalf of ICC at today's event that is organized by ICC Bangladesh. I warmly thank ICC Bangladesh, Mr. Rahman, and everyone who has made this event possible. And of course, we appreciate the opportunity to interact with the Bangladeshi business and arbitration community, learn from your experiences and respond to your needs. And also, of course, reply and shed light against the perceptions which I think have already been identified as potential misunderstandings with regard to ICC arbitration. We are here to help, and we are here to explain exactly how ICC arbitration works. For an institution like ICC, having worked for over a century to become the leader in dispute resolution worldwide, and the world's most preferred arbitral institution, your voice counts, and your voice means a lot to us. This event is taking place at a very crucial time. I don't know if Mr. Rahman, can you perhaps mute yourself? Would that be possible? This event, as I was saying, is taking place at a very significant time for ICC, given that the ICC Court is celebrating its centenary year. The I in ICC, which is the International Chamber of Commerce, is actually a very key component part of our identity, and it is also one of the key factors that allow us to discharge our mission, because what we do is indeed truly international. And that mission is not a mission, dear colleagues, that is only limited to providing dispute resolution services. There is a much broader mission, going beyond what other dispute resolution service providers do. We are here to ensure access to justice and the rule of law by providing accessible, affordable, predictable, and efficient dispute resolution and dispute prevention services to everyone, every day, and everywhere. Now, the reason why ICC was formed back in the 1920s and the aftermath of the First World War was to ensure, basically, that the atrocities of that war would never be repeated. And our founders, and you heard about them already, the Merchants of Peace, considered that trading between companies, between states, between individuals, and across borders, what we would call today international trade, in other words, was the way to embed global peace. And that concept is simple. If people, companies, states, etc., manage to engage within a defined, predictable international trading setting that leads to good commerce, that would lead to a flow of funds, that would lead to growth, and then growth leads to prosperity, and where there's prosperity, war and strife have no place. So much as that it is a very economical way of approaching the ideal of peace, and putting that concept into action and in creating, of course, International Chamber of Commerce, I very quickly realized that in order for all of that to happen, you also need to provide a dispute resolution mechanism that will detach any disputes from that might arise in the context of international trade from local courts, because one side may not actually have trust in the courts of the other party's place, or because the ability or the capacity of the local courts to appreciate the needs and function of international trade may not yet have fully developed, or also for other reasons. And that is how arbitration, particularly commercial arbitration as we know it today, came to be. But let's focus specifically on the ICC Court. Now, the International Court of Arbitration consists of 195 members from 116 countries, including Bangladesh, as you've just heard. Bangladesh is represented by Mr. Hossain, 17 vice presidents, and 1 president. Claudia Salomon, who's here with us today, the first woman elected to this office in the court's 100-year history. Now, each court member is involved in all types of decision-making activities of the court, including the scrutiny process, which is that unique feature of ICC arbitration that ensures that awards are of the highest possible standard of recognition and enforcement and quality. So scrutiny is a unique feature that leads to a valid and enforceable award, and an award that the parties can comprehend and accept. Since the court was established in 1923, it has played a seminal role in making arbitration the preferred method for resolving disputes between parties from different countries and creating the legal architecture for the recognition and enforcement of arbitral awards. Let's take up one example, the pioneering role that ICC played in the drafting and the adoption of the 1958 United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards, known as the New York Convention. To meet the needs of international businesses and to facilitate international trade, ICC sought already prior to the end of the 1950s to overhaul the then applicable Geneva Convention of 1927. The first draft of what became the New York Convention was prepared by ICC. And through its expanded network, ICC encouraged countries around the world to ratify the New York Convention. Now, with more than 170 signatory countries from around the world, the New York Convention has almost universal acceptance and has become one of the most successful treaties and a cornerstone of international arbitration as we know it today. Returning to present, ICC is determined to meet the evolving needs of a broader range of businesses and markets by providing thought leadership in dispute prevention and resolution, including the enforceability of awards. And that is why we are here today, working with ICC Bangladesh to invite a brilliant panel of Bangladeshi business and legal representatives to discuss the challenges and the best practices for arbitral award enforcement, together with the president of the court, Claudia Salomon. We're very happy, dear colleagues and friends, to bring our 100-year leading expertise to you and grow with all of you and support you and your company's needs. With that, I wish today's event a great success and look forward to a continued engagement with ICC Bangladesh, and individually with all of you throughout our centenary year and beyond. Thank you very, very much.
Thank you very much, Alexander. It's been a great pleasure to have you with us. But as I said, once again, I would continue to repeat it. Not only today, I would continue to repeat it anywhere I met your president, the ICC chair, or anyone, that they should come to Bangladesh to see for themselves, not only for arbitration, but also how the Bangladesh is performing, and more importantly, how Bangladesh National Committee is performing compared to the hundreds of national committees worldwide. So that is very important. The seeing is believing. So that is very, very important from that point of view. I would like to say we have also state-of-the-art, the new secretariat of the Bangladesh, ICC Bangladesh, which we set up only last year, with all facilities that is needed for having the virtual, non-virtual, physical, including eating facilities. Now that I would like to say that we start our roundtable discussion, and our chair of ICC Bangladesh Commission on Law and Arbitration, Ms. Nihad Kabir. She's a barrister at law. As I said, I have already introduced her. to all of you about her career, and more importantly, she is more proactive person in not only in the area of law, but also in the overall trade and investment, because she was also the president for a number of years in the Metropolitan Chamber of Commerce, as I said, which is the oldest chamber, 115 years old chamber of commerce in the country. And she represented the whole business community and the economy. And now, over to you, Nihad. I can now retire, no?
Thank you very much, Mr. President, Mr. Rahman, for the very kind introduction. A very warm welcome to all of you at today's program. We have just heard a very succinct but very informative presentation from Mr. Alexander Fessas, and thank you for that. As you all know, well, at least all of us who have joined from Bangladesh, today's topic of discussion was chosen carefully as challenges and best international practices for enforcement of foreign arbitral award, because we have faced this issue a number of times in Bangladesh. In fact, not just of foreign arbitral awards, but also of local arbitral awards. One of the principal grounds for challenging and being able to have awards set aside is the ground of public policy, which is often interpreted rather widely to enable an award to be not to be enforced. So today we would like to hear from our distinguished panel of experts as to the challenges they have faced and how they have overcome those in having arbitral awards enforced, either in Bangladesh or outside. At the outset, I would like to invite Ms. Claudia Salomon, President of the ICC International Court of Arbitration, to deliver her speech. And we would like to hear what are the best international practices dealing with this issue. Let me introduce Ms. Salomon, who is the first woman president of the ICC Court in its almost 100-year history. Claudia is the global co-chair of the international arbitration practice at Latham & Watkins. She focuses her practice on energy, construction, technology, post-M&A, and joint venture disputes. She regularly sits as an arbitrator. Claudia previously served as vice president of the ICC Court and co-chair of the ICC Commission on Arbitration. Claudia, the floor is yours.
Terrific. Thank you so much. I want to thank ICC Bangladesh for working with us to put together this program. And thank you, Nihad, as the chair of the ICC Bangladesh Commission on Arbitration and ADR. I'm very grateful to have the opportunity to speak with you about the role of arbitration, and specifically the role of ICC arbitration in helping Bangladeshi companies, and address the specific question about the enforcement of arbitral awards. I think I'll have the opportunity as well to address what I think are the myths about ICC arbitration, whether that's the process or the cost. But first, let me take a step back, because on the 19th of January, just 2 months ago, we did launch our centenary, the exact date, 100 years ago, when the ICC International Court of Arbitration was founded. As was mentioned, in the wake of World War I, a pioneering group of entrepreneurs who called themselves the Merchants of Peace had the idea that they would promote peace and prosperity through cross-border trade. And they had an understanding that if there was going to be more cross-border trade, there needed to be a mechanism to resolve cross-border disputes. So in 1919, they founded the ICC, the International Chamber of Commerce, And 4 years later, on the 19th of January, 1923, they founded the ICC International Court of Arbitration. And I would submit that for this 100 years, we have been unwavering in our commitment to access to justice and the rule of law. And the ICC has played a seminal role in making arbitration the preferred method for resolving disputes between parties from different countries. As Alex mentioned, ICC played the pioneering role in the adoption of the 1958 Convention on the Recognition and Enforcement of Foreign Arbitral Awards, known as the New York Convention. ICC indeed prepared the first draft of what became the New York Convention. And through its expanded network, ICC encouraged countries around the world to ratify the convention. And now it has almost universal acceptance. Because with the presumption that arbitral awards are enforceable, the New York Convention is one of the most important and successful treaties as the cornerstone of international arbitration. There is no equivalent global treaty providing for the recognition of court judgments. So this enforceability of arbitral awards is really the key reason why parties choose arbitration in cross-border contracts. And let me just explain this further with just a very basic example. Because if we take a Bangladeshi company entering into a contract with a US company, the US company may want to be in US courts and may have the bargaining power to insist on US courts. But if their counterparty, the Bangladeshi company, does not have assets in the United States, it would be very difficult for that US company to enforce a US court judgment outside of the United States, and US companies may not want to litigate in Bangladesh. And likewise, Bangladeshi companies may prefer to be in Bangladeshi courts, but if their counterparty doesn't have assets in Bangladesh, even if the Bangladeshi company has the bargaining power, it would be difficult for them to enforce the court judgment outside of Bangladesh. And that is the reason, the key reason why parties choose arbitration, because they can take the arbitral award and presumably enforce it around the world with limited grounds for challenge. Although we are obviously hearing some ways in which those grounds for challenge may be interpreted more broadly than in other places. So we are focused on that crucial moment when parties are entering into a contract and deciding whether to use litigation or arbitration. And if they choose arbitration, what is it that is going to make them choose ICC arbitration? I submit to you that parties are choosing ICC arbitration because they trust ICC. When entering into a contract, the parties hope all goes well. They certainly hope a dispute does not arise. But if it does, they need to know that they will have an avenue of recourse, that they have a fair and neutral process. In short, that they have a process that they trust. ICC has built that trust over the last 100 years in 3 key ways. First, through our scrutiny process. This is a unique feature of ICC arbitration, ensuring that ICC awards are the highest possible standard. During the scrutiny process, the ICC court members review the draft awards to ensure that the reasoning is clear and all of the claims and all of the defenses have been taken into account. No other arbitral institution does this. I will repeat that. No other arbitral institution does this scrutiny process. And why do we do it? It goes back to why parties chose arbitration in the very first place: enforceability. We are providing this service to ensure the award has the highest potential for enforceability. Second, we are the only arbitral institution that is truly international, not linked to any geography or subject to political winds. We have parties using our services from over 140 different countries, including, of course, Bangladesh. ICC arbitration took place in over 100 cities around the world, not just in Singapore or Hong Kong or Paris or London, but literally all over the world. And our arbitrators are from almost 100 different countries. Let me emphasize some statistics about Asia. About 25% of our parties in the last 5 years come from Asia Pacific. The top countries are, not surprisingly, China, Korea, India, Singapore, and Japan. But in the last 10 years, we have seen parties from Bangladesh, including state entities. We see Bangladeshi parties as claimants, and we see them as respondents. And we see ICC cases applying Bangladeshi law. We've continued to safeguard the legitimacy of arbitration with a truly international, independent, and neutral ecosystem to resolve disputes. Third, our case management team, I can say, is second to none. We have case management teams in Singapore and Hong Kong. We also have case management teams in New York, Abu Dhabi, Sao Paulo, and of course, our headquarters in Paris. But it means you do not have to reach out to somebody in Paris. You have the ability to call case management teams in Singapore or in Hong Kong. We are focused in this way on assuring that every aspect of international arbitration has what we call a client mindset, that we are responsive and accessible, and assuring that we are responding to and hopefully exceeding parties' expectations. Now, let me just highlight 3 additional elements. The first, we know the parties are concerned about time and costs. In 2017, we introduced our expedited procedures, which apply for cases under $3 million US. In those cases, the award is issued within 6 months of the case management conference and are resolved by a sole arbitrator. We now have had over 400 expedited cases, and we can say that the process works. We've also seen parties opting in to the expedited procedures, even when the amount in dispute exceeds over $100 million US, because the value of predictability, of timing, is key for them. Second, we know parties want predictability of costs. Our fees are based on what we call an ad valorem system, which means they are based on the amount in dispute, not the hourly rate of the arbitrators. This means you can use our cost calculator on our website. Type in ICC cost calculator in any search engine and you will find it. And you will be able to type in the number of arbitrators, the amount in dispute, and see the minimum, maximum, and average costs of the arbitration. And you can then budget for that. We rarely, if ever, see cases over the maximum. Almost all cases are at the average, and if the parties settle, fees are reimbursed. And 3, we know parties want easy access to their case materials, and that is why we launched ICC Case Connect, an online platform where in-house counsel, outside counsel, arbitrators, and the case management team all have access to the case file anytime from anywhere. So I look forward to our discussion today, to the questions you might have, and thank you again for everyone who's joined us today.
Claudia, thank you very much indeed. That was a very succinct presentation of some of the issues that we have been struggling with here and which we have raised. I'm sure there will be more questions for you as we go along. But a couple of the things that you mentioned were really very, very interesting. One is the expedited procedure, and parties with larger claims actually opting in for that expedited procedure so that they get that the resolution within the 6 months. And also that if the cases are settled, then the fees are reimbursed to the parties. We know that ICC is a very trustworthy name, but despite all of this, we find that there is a little bit of perhaps reluctance to go in for ICC arbitration. And the reasons, as we are saying time and again, is cost most often. But we will hear from our very distinguished panel here. Let me invite, first of all, Mr. Mir Nasir Hossain, one of the very senior business leaders of the country. And as you have heard, he is the managing director of Mir Ceramic Limited, Mir Akhter Hussain Limited, and Mir Holdings Limited. They were some of the largest construction contractors in Bangladesh as well. He was the president of the Federation of Bangladesh Chambers of Commerce and Industry, and senior vice president of the SAARC Chamber of Commerce and Industry, and the vice president of the Confederation of Asia Pacific Chambers of Commerce and Industry. Mr. Hossain, may I request you to kindly speak? If you could kindly limit yourselves to about 4 or 5 minutes, then we will be able to get in some questions at the end of our allotted speaking times. Thank you.
Thank you very much, Madam Chair. Distinguished guests, ladies and gentlemen, it's indeed an honor to be part of the Centenary Celebration of ICC, and more so from Bangladesh through digital platform. On behalf of the business community of Bangladesh, I express heartiest congratulations to ICC and join hands in collaboration to mark the 100th anniversary. Today's topic is about enforcement of foreign arbitral awards in Bangladesh. Bangladesh has come a long way since 2001 with the promulgation of Arbitration Act 2001. The concept of arbitration came as alternate dispute resolution in an effective and efficient manner. But with the passage of time, the procedural dozens and repeated intervention from appointment to the enforcement have made it into a complicated and cumbersome procedure. Not to mention the time involved to finally get the effective result. And by result, I don't mean getting the award only. I mean the final benefit of getting an award. As with the legislations, it may require amendments, and ICC Bangladesh is playing an important role in this regard. To make arbitration procedure meaningful in contracts generally, I would like to highlight a few essential points, which I believe ICC, being the time-tested centenarian, can deliver in Bangladesh and for Bangladesh. Number one, training, upskilling, conducted at a regular interval, not only on procedural matters, but on the concept of why it is alternate to regular litigations. Training should not be confined to lawyers, both in-house and external, knowledge sharing, and introducing the rules and technology to arbitrators and honorable members of the judiciary. Number two, with the advancement of digital technology, and now I'm hearing the chat GPT interested in legal work, ICC needs to explore fully online effective arbitration. In fact, this could reduce the cost and time for businesses. During the pandemic, Bangladesh didn't waste time to avail the advantage of digital platform in conducting court cases. Number three, upskilling ICC Bangladesh to receive requests for ICC arbitration and to facilitate online arbitration. Number four, multiple currency option for parties to ICC arbitration for fee payments. Regarding payments, actually, I'm in the construction industry. We have got in our international contracts, ICC option for ICC arbitration. Most of the Bangladeshi companies feel that it is very expensive, and also it's difficult to fix up a sitting place. Normally, the other partner wants to have sitting in their own countries. Sometimes it becomes very difficult to attend there, and visa issues and all other things. So that's why nowadays SIAC has been chosen as one of the best platform by the Bangladeshi companies, as because it's less costly, less expensive, and also easy to attend the arbitration process in Singapore. So ICC will have to look into the matter. It has already been addressed by Madam President. These are surely not exclusive, exhaustive points, but hopefully these will generate thoughts for improvement and efficiency. While we celebrate the last 100 years of success of ICC, we lay the foundation for the next 100 years and more to come. With these few words, I'd like to conclude. Thank you all. Madam Chair, I think I'm within the time frame.
You are much faster than the time frame, Mr. Minister. Thank you very much indeed, and thank you for making the point that it is very important to have training and knowledge sharing with our arbitrators and our judiciary in Bangladesh, particularly in what grounds can really be taken and explored in an application for setting aside an arbitral award, and that the court should not be going into the matters on the merit, on the merits of the matter. You've also mentioned, and we have found this as lawyers in Bangladesh, that SIAC arbitration is now very much a preferred option, not just for the cost, but for the convenience. So this is perhaps something that the ICC may need to address. Without further ado, let me move on to our next speaker, Mr. Kutubuddin Ahmed, Chairman of Envoy Group and ICC Bangladesh Executive Board member, who is also one of the foremost business leaders in Bangladesh. And he also has the distinction of being one of my first clients when I joined as a very junior lawyer sometime in the early 1990s. He was also former president of my chamber, the Metropolitan Chamber of Commerce and Industry, and is a leading garments exporter from Bangladesh. Mr. Ahmed, may we have your views on ICC arbitration and arbitration in general, please? Thank you.
Just to add, he is also in the construction as well as in the textile industry.
So thank you very much, Mr. Nihad, for giving me this opportunity today. So let me congratulate ICC International Court for observing this centenary celebration. So ladies and gentlemen, so Mr. Nasir already explained what are the key problems we are facing, or what are the expectations from the business community in terms of ICC Court of Arbitration. So, and also, but what I can say that our president, our very respected president, Mr. Mahbubur Rahman, he has been trying to have some sort of solutions with to formulate the government laws so that it can effectively implement as an alternate dispute resolution. So he has been talking with the law minister and other important dignitaries. We continuously hammering. But I know that this is, like as a businessman, let me tell you, not the other aspects of it, because all the speakers have talked about the important aspects of the law, but since my ignorance in law is there, so I don't want to repeat that one. But from my side, I can tell that why people are not very interested, or business community is not coming forward the way we want for arbitration. This is only, I can say that they want quick disposal of everything and effective, not only quick, also effective. Well, monetary things is not very important in this respect, but it is important in terms of, how big the deal is, or the amount will be. But the most important thing is, even we are awarded this award, arbitral award, then even then they can go to the court and can give this injunction, or they can stay, or they can go for higher court as well. So, but arbitration has, in my opinion, it should be unique. Like once it is done, both parties has to execute and respect that award. That in that case only it will be effective, I consider. And then we need a lot of campaign to popularize this arbitration, because a lot of ignorance is there among the business community. Business community is not fully aware. Those we are involved in these sort of things, we know what is arbitration, how the alternate dispute resolution can be done, that, but is not very popular with the common. I'm talking about the local side. Foreign side, as you very rightly said, that people want Singapore or UK, Hong Kong, not really, but in my opinion, either they choose UK or Singapore law. The reason is the reason is very simple, because we were at one stage British colony. So Singapore, Hong Kong, Bangladesh, all were British colony. The law is very much similar. So, and these laws emerge from that British law mostly. So this is one thing I can tell, that if you make a big campaign, or if we have a lot of seminars, symposium, or workshop, whatever you name it, among the business community, and to tell them about the good part of it, what is the benefit, what is the merits, and also the cost. Of course, we have to tell them, and also the time frame. Time frame is also very important. Depending on, but Bangladesh, I know we have started our arbitration center, but though it's not very successful at the point of time, but eventually, definitely, we have a bright future. I know people will have a lot of confidence on this, and people will go for it. Even I don't know whether, like UCP 600, which is Uniform Customs and Practice for Documentary Credits, where we can put this arbitration clause mandatory. Then, I mean, in the LCs. So we have a lot of LC dispute in various manners. So that can be, could be an effective tools to popularize this. I don't know, it's there in Uniform UCP 600, which was revised in 2007, whether it is incorporated in that book or that documentary laws. So these are the things, like I strongly believe that, like we have to tell the business community, the message should go very fast, very crystal clear, that it is a very effective tool, you can get benefit out of it. There are merits on it. And if you can capitalize that, only then it can be a successful tools for the arbitration law in Bangladesh. And also we have to try for formulation of our local country law in light of our arbitration center, our arbitral award, because it has to be enforced immediately, cannot go by court and others. They can put a lot of injunction and other things. So as I said, my knowledge is very poor in terms of law. So what I said is what I feel from my point of view as a business man. That's all. So thank you for everybody for patience hearing. Thank you.
Thank you very much, Mr. Ahmed. I mean, we really need to hear from the perspective of business why they would use arbitration. There's a question already from one of our audience members, that is it more costly to go for arbitration than to go for litigation? In the context of Bangladesh, just to put it in context, as you all know that the World Bank's Doing Business Index put Bangladesh at number 189 out of 190, I think, in dispute resolution. As a commercial lawyer of more than 30 years standing, I find that foreign investors, one of the principal concerns is the time taken for dispute resolution. And the figures are something like, for the first instance of dispute resolution, where it takes about 87 days in Singapore, it takes something like 1,435 days in Bangladesh. These are not exact figures, but something like that. And we've all faced that issue. So in terms of time, certainly litigation is more expensive in Bangladesh, if not in terms of actual cash costs. I would now like to go to Mr. Samir Sattar, who is currently the president of Dhaka Chamber of Commerce and Industry, which is a preeminent chamber for SME enterprises. And he is an advocate of the Supreme Court of Bangladesh. He has worked on and appeared as counsel in several international arbitrations held under the auspices of the ICC, Arbitral, LCIA, SIAC, and ICC rules. So I would like to ask you that since you have been extensively involved in domestic and foreign arbitration, what is your take on the ease of using ICC arbitration as opposed to the others, and what challenges you have faced in enforcing ICC awards or any arbitral awards for that? Thank you.
Thank you, Nihad. It gives me great pleasure to be here with all of you today to join the centenary celebration of the ICC International Court of Arbitration. I thank ICC Bangladesh for inviting me here today, and I also like to take this opportunity to congratulate the International Court of Arbitration on stepping into its 100th year. Arbitration being in practice, primarily in this area, both here and my stint in London, is an area that I hold very close to my heart. But enforcement, which is the discussion of today's roundtable via Zoom, is enforcement of foreign arbitral awards. I think enforcement is key to upholding the sanctity of arbitration process. We have ICC arbitral awards go through a different level of scrutiny. They are awards of the highest possible standards, but if they cannot be enforced very easily in places like Bangladesh, then the award will just be of paper use to its users. So from that perspective, I will not talk about the best international practices, but I'd rather like to focus on two things which focus on challenges of enforcement of foreign arbitral awards in Bangladesh. Whether it is ICC or whether it is SIAC or whether it is LCIA, I'm not going to go into that. What I want to focus on is that two things. One thing that you've touched upon, which is the public policy issue.
Yeah.
And the other thing is the length of time that is required to have any international arbitration award to be enforced in Bangladesh. Now, the parties may go through a very expensive process of an international arbitration, but if you look at the way the Bangladesh legal structure is framed, in order to do any sort of enforcement, you have to come to the district court for enforcement. It's a court that is already marked with delays, as a result of which any enforcement does not take place very easily, just because of the layer at which it starts. So you have the district court, and then you have the high court, then you have the appellate division. So it has to go through a three-step review before an award can be actually enforced. And from that perspective, I think many countries have amended the arbitration law so that the enforcement is done in a very quick and efficient manner. Now that I wear the hat of the president of Dhaka Chamber of Commerce, and I'm hearing the views of the business houses, they want a quick solution, as Mr. Kutubuddin Ahmed said. They want a very efficient solution. Once they go through a lengthy arbitration process, they do not want to be stuck in courts trying to enforce that. So from that perspective, from Dhaka Chamber as well, we're trying to do some policy advocacy to amend the Arbitration Act so that the definition of court is changed to start at a higher level, which is in the High Court. And this is what's been done in India, and we can follow their best practice as well. The second thing that I would like to touch upon very quickly is the issue of public policy, which Nihad, you've already touched upon at the very beginning. Because public policy, as they say, is an unruly horse which cannot be tamed. And we need clear guidance as to what this public policy entails. Because at this point in time, this gives a free discretion to the judiciary handling the enforcement to interpret it as to what they see public policy should be. And again, in India, they have changed or amended the Arbitration Act to include a somewhat definition of their public policy, which we can also follow. So these are the two things that I wanted to touch upon. I know that I'm short of time, but I think whether it is an ICC arbitration or a SIAC arbitration or an LCI arbitration, what is most important now in relation to enforcement of foreign arbitral awards is a swift and easy way of enforcing these foreign arbitral awards. So they are not, loitering around in the courts of Bangladesh, and parties are just going round and round, months and months, years and years go by, and they can't enforce their arbitral award, which they have attained actually through spending a lot of money on foreign counsel and an expensive arbitration award, whether it's ICC or any other foreign institution. Thank you.
Thank you very much, Samir. Well, we have all sort of gone round and round the merry-go-round in enforcing awards here. I think we really need to look at the best practices and see how we can amend our law to make sure that it is speeded up. The work is going on it, but I think we can learn from our interlocutors here today and see how it can be done even better. Our next panelist is Mr. Mahbubur Kabir, who is an advocate of the Supreme Court of Bangladesh and head of chambers of Mahbubur Kabir and Associates. He has represented many clients in both international and domestic arbitration and has extensive experience in ICC arbitrations, having represented both state entities and contractors in a number of construction and energy arbitrations. Mahbubur, if I may ask you, have you been involved in arbitrations where the awards have been enforced outside Bangladesh? And if that is the case, how do they deal with this issue of delay?
Madam Chairperson, Mahbubur is joining from New York. She's very early in the morning there. So,
well, he looks quite bright and awake.
yeah,
That's all right.
Very
We lawyers are used to working 24 hours.
That's right.
Thank you very much for having me. It's actually a pleasure to speak in this ICC Centenary event. Going to your question, where the award has been issued outside Bangladesh and enforced in Bangladesh, is that the question?
Yes, or enforced outside. I mean, we're trying to find, how is it that awards are enforced faster overseas than in Bangladesh?
So technically, from my experience, if I may say that the ICC arbitrations that I'm engaged in, both are, involving Bangladeshi parties and foreign parties. Now, in those arbitrations, one of the award, which is, we are about to expect the award right now, the primary concern of the client is actually enforcement, because they're going to enforce it. They are looking for assets outside Bangladesh, but technically they're more focused in enforcement in Bangladesh. And, when it comes to enforcement, they're concerned, this is a client where, they've done an in-depth research of, how the enforcement can be done and what are the, the bottlenecks. Primarily what we have seen in Bangladesh right now, that the Supreme Court of Bangladesh, they're taking from time and again, taking approaches which are very pro-arbitration. For example, the issue that was raised by Mr. Samir Sattar about public policy, our court in a recent judgment has actually given a definition of what is a public policy and when can the award be considered to be contrary to public policy. There's 3 factors which was introduced, and those 3 factors are actually the similar ones which have been included in the Indian Arbitration Act. Now, coming back to enforcement, when it comes to enforcement, we all know how the problem is. What the problem is basically the court proceedings, where it's really sluggish in nature and it's very slow and we have to push it through. As Mr. Sattar has also stated, if we change for foreign arbitral awards, if we remove it from the Dhaka District Court and take it up to the High Court Division, it may be faster. But I think what we typically need is we need procedural laws. We need arbitration rules under the Arbitration Act, which directly relates to enforcement. This will go a long way in instilling confidence on foreign investors or in enforcement of foreign arbitral awards. Another thing which I find a challenge for ICC arbitration is basically like has been mentioned, is costs. For example, when a Bangladeshi party is arbitrating with another party, or a regional party, and the place of arbitration is determined to be in Paris or in London or in Geneva by the ICC Court, that basically puts up a lot of pressure on the clients. And when they have to bring in witnesses, experts, and all the individuals from Bangladesh or a regional part, from the subcontinent to a place in London, it's expensive. And along with the legal costs, that really piles up. So that is something which I think for ICCs to look into as well. And for enforcement, my 2 cents would be, is that we need arbitration rules to be implemented. Arbitration rules categorically identifying, the procedural changes for arbitration. That can be done by having a separate specific court for arbitration and, to deal with it. And for example, in the High Court Division, we have a specific court for arbitration, but we need a specific day in a week where only arbitration matters can be heard. That may be a simple solution to a very complex issue. Due to the constraint of time, I think I will wrap up here. Thank you very much for having me.
Thank you very much. There's a very sort of to the point observations on what is happening with regard to arbitration awards in Bangladesh. In particular, again, you're speaking about the cost and the venue of the arbitration. And of course, the parties are free to discuss and choose the venue. But we do find that London, Paris, or New York becomes very expensive. For us, again, in Bangladesh, Singapore now is a very accessible place and a familiar place. So that leads us there. Regarding having a specific court dealing with arbitration matters, the successive chief justices in Bangladesh have been approached for this. And I think there is now a possibility that we will be able to have more concentration on this sort of dispute resolution by either segregating a court or some time off that court for this matter. Thank you very much, Mahbubur. Thank you for joining from New York, and I think we can let you go back to sleep. Our next speaker is from the public sector, Mr. ABM Rahman. He is an engineer by profession and is the additional project director, superintending engineer of the Sasek-Dhaka Sylhet Corridor Road Investment Project. He's a member of the Public-Private Partnership Cell of the Roads and Highways Department. He has more than 17 years experience in planning, development, execution, and management of highways in Bangladesh, and more than 14 years experience of working in relation to large-scale highway development projects financed by multilateral development banks. Sataj, if I may ask you, in government contracts, how do you look at arbitration clauses? Have you found that recently there is more of an insistence on having arbitration in Bangladesh rather than overseas? What rules are preferred? And I don't know, have you actually had to represent or be part of an arbitration team from the government side? Please let us have your experience.
Okay, first of all, thank you, Barrister Nihad Kabir for having me in this important event. And I am privileged to talk here on the eve of a centenary event of ICC. And I'll be very happy to talk on the issues and your questions. So since last 3 decades, Bangladesh government has been implementing larger scale infrastructure projects financed by both the development partners and government of Bangladesh funding. And arbitration is very common and very essential element in the government contracts. To be specific, my organization, Bangladesh Roads and Highways Department, who is responsible for construction and management of more than 22,000 kilometers of roads in the country. And we are improving our roads, and we are widening our bridges, constructing new bridges all along this corridor. And contract size of more than 100 million US dollar and even more is very common nowadays under Roads and Highways Department. And for international competitive bidding in the contract, we keep provisions for internationally accepted alternate dispute resolution mechanism under various arbitration institutions. Like we have ICC arbitration provision. We also have provision for UN CITRAL on the top of the Domestic Arbitration Act. And in recent days, public-private partnership projects are coming up in this Roads and Highways Department and in highway sector. And we are also following SIAC. We are preferring SIAC for the arbitration. So if you ask me whether any specific rules or procedures were followed on our any previous contract, yes, I can give you 2 examples where arbitration took place. Many speakers, they have shown their disappointment of not having the arbitral award, but I can say that on Dhaka-Sylhet Highway, National Highway 2, in the Voirab Bridge, the construction company was from UK, and one arbitration took place. The arbitration seat was in Singapore, and they actually got the arbitral award, and they were paid with all the award amount from the government. So that's a bright side. On the flip side, on 2012, a South Korean construction company, I can recall, they got arbitral award from ICC Singapore, where ICC arbitration rules were also followed, but their award is still not enforced, as government was aggrieved and then went to the court. So for arbitration, the challenge is that for arbitration, it takes time, because from the government side, actually, no one at the beginning of the contract, they apprehend some type of dispute, but maybe no arrangement of financing arrangement for fees for arbitration and relevant cost. And also for many decisions, government is aggrieved and they have to go to the court. So generally speaking, the total process to resolve a dispute or arbitration, it takes much time than it should be. the international arbitration, despite its advantage of effective dispute resolution, has had a few significant challenges in the context of Bangladesh. The challenges are on appointment of arbitrators, defining and enforcing its minimum standard and competence, the issue of the cost of arbitration, and definitely enforcement of arbitrational awards. Having said that, arbitration opened doors to international commercial arbitration and making it an attractive place for the international commercial investment. So definitely arbitration mechanism is effective, and we put those arbitration mechanism in our contracts. But yes, there are some places where we have areas for improvement. So that's all from me, Barrister Nihad Kabir. Thank you very much for giving me the opportunity to talk.
Thank you very much. But before you end, I have a specific question.
Yes.
Have you noticed recently that in contracts with the government, that the government side is insisting on arbitration under the Arbitration Act instead of under ICC rules or Arbitral or ICC rules? Have you seen anything like that?
Yes, look, we have actually two different type of contracts. One of those contracts are financed solely by government of Bangladesh. Yes, where the domestic arbitration, yes, the Arbitration Act is predominant, and also in those contracts, mostly the parties are from Bangladesh. So they also don't prefer to go for international arbitration, and they are happy with the domestic arbitration. But apart from those contracts, the large scale contracts, those are actually financed by World Bank, Asian Development Bank, and other development partners. So in those contracts, obviously, we follow ICC rules of arbitration, and also we keep provision for UN Central and sometimes SIAC as well.
Okay, thank you very much indeed. Very interesting point that you made, that while there are arbitration clauses and dispute resolution clauses, often there is no budget for that in the contracts. And then, of course, from the government side, it takes quite some time to get the budget and get moving on these issues. So that also contributes to the delay. Thank you very much indeed for taking the time to join us today. Our last panelist today is Mr. Mohammed Farooq Rahman, again, an advocate of the Supreme Court of Bangladesh and head of Rahman's Chambers. He has he has 16 years of work experience as a specialized lawyer in the field of dispute resolution. He's a fellow of the Hong Kong Institute of Arbitrators and member of the Singapore Institute of Arbitrators. He's a panel arbitrator of SARC Arbitration Council and Shenzhen Court of International Arbitration. China, also a CEDR accredited mediator and a panel mediator of Bangladesh International Arbitration Center. Farooq, with your accreditations, with all these institutions, give us a comparative view on what you have found to be an effective mechanism here. Is it ICC? Is it some other rules? Give us the benefit of your experience. Thank you.
Thank you, Nihad, for giving me the floor. I congratulate ICC Court on celebrating its centenary, and thank you for ICC Bangladesh for appointing me as a delegate for ICC Commission on ADR and Arbitration. Thank you, Nihad. The questions, yeah, definitely I'll be sharing two experiences. There was someone in the chat also asked for some experience. So first of all, I'll be sharing two experience with ICC case, which I was involved in 2006. I was acting as a legal consultant for PowerCell. Probably that was the very first case I have searched and went to the High Court and Supreme Court against the execution of arbitral award. So what was happened? It was a barge-mounted power plant. The company was involved. BPDB is a local off-taker, and then Smith Cogeneration was the actually SPV, and they were the contractor. And then there was a disputes involving delay in construction and delay in getting license and permit. And then there was a challenge, and arbitration took place under ICC rule, and it took place in Paris. And then BPDB appointed their arbitrator, Salomon Hossain was the arbitrator from BPDB side. And then it also, but unfortunately, they haven't sent any legal representative to represent their case. They just appointed arbitrator, and it went in favor of the contractors, Smith Cogen, because effectively government seems to have not provided the the licenses on time, or did not facilitate under implementation agreement. Then what happened? The award was contract was signed in 1999, and the award was given in 2000. And there was a local court. The Smith Cogen also tried to enforce the award in other jurisdictions. In US, a few courts in US, they tried to enforce the award, but effectively, probably there was an absence of asset. They could not enforce it. Then they came to Bangladesh for enforcement. But what happened? The local court, there was a separate suit has been filed, and court also passed injunction against the award. And that injunction was actually vacated, dismissed by High Court in 2009. And then it went to the appellate division, and it was dismissed by appellate division in 2015. So the award actually became effective and, ready for enforcement in 2015. It's almost like a delay of 15 years. That is the actual situation. I was involved as a consultant of PowerCell at that time. I have been handling it only for 2 years while I was a consultant, 2007 to 8. Then I just, the rest of the report I obtained from the court cases. So this is what was very interesting. Definitely, there's a procedural delay, as we all highlighted, including you, Appa, and Samir, and Margot, and okay. And then to your specific question, the comparison. I also had an opportunity to work as a consultant with Deloitte on a. It's exactly the comparative study was there, because there have been different kind of construction. Power sector contract has been kind of in practice, like different entities of power sector has been preferring different kind of arbitration forum. Some ICC, some SIAC, there was like a default clause, ICC was there, and HKISC was also there. So we have been given a task of consolidate and combine and make a recommendation of a suitable clause. So we have been through this, have collected all the contract involving particularly power sector. And then, there was a different variations. So, and then we made one single clause. There was obvious few reason was involved, and we had to, in few cases, choose for exceed because bilateral treaty was involved. There was an issue of claiming diplomatic immunity was also there. So, but other than that, we recommended ICC in, or probably one case is also recommended CR. But what we understood from there, from the exercise, there is a preference in the local community to go for CR. Probably they are not aware of the benefits the ICC have. I'm very much familiar with the arbitration management. The way they manage it, it's absolutely unique. And the reason it's very much suitable for Bangladesh, before holding arbitration, they take into account the entire picture. What are the issues involved? What practice areas are involved? And what expertise may be required? So that case management is definitely, as Honorable President is saying, ICC Court President, it is really something which the Bangladeshi party should be taken benefits of. But there is definitely issues of lack of awareness. Even our legal community is also not much of an aware of the benefits of ICC arbitration. And of course, another advantage of scrutiny. And another thing that comes to the minds of the business, as Mr. Nasir was saying also, Mr. Kutubuddin was referring that, they rather tend to go to the Singapore. Singapore, it's convenient, local, but very people know that ICC also have a regional center, and they also have a case management, the activities there. So if these things are promoted, and the advantage that ICC have over other arbitration arbitration forums and rules is definitely unique. If these matters are explained and comparing cost and the case management and expedient process they have, definitely ICC, if personally you ask me, I would go for ICC. Thank you, Nihad.
Thank you, Varun. Thank you for sharing your experiences. While we're officially out of time, I think I've been informed by by our Secretary General, Mr. Rahman, that we can continue for some more time, and those who can remain with us, that would be great. We have received some questions from our guests, which have, in fact, most of them have been answered in the chat box by Alexander and Donna. But if I can just quickly read some of them out, that is that arbitration is a unique method to resolve disputes. In the perspective of Bangladesh, what's the volume of these cases, and what initiatives are being taken to increase this? I think we've had some idea from our panelists, but if any of you would like to respond specifically at the end. There's a question of how the expedited procedure differs from the regular procedure, and how many people are placed for case management in regional centers like Singapore, an idea about the cost, and whether it is necessary to be a member of ICC to go for arbitration. So the responses have been that in general, ICC has 1 counsel and 2 deputy counsels, as well as several assistants for 1 case management team, like the one in Singapore. Globally, ICC has 12 case management teams in Paris, Singapore, Hong Kong, New York, Sao Paulo, and Abu Dhabi. It is not at all necessary for anyone to be a member of ICC to go for arbitration. Once there is an arbitration agreement, the parties can go to the ICC for arbitration. The costs can be calculated, as Claudia also said, that if you go to the website, so you can calculate the range of the arbitrator fees and the ICC fee well in advance by using the ICC's cost calculator, which is an excellent tool for predictable costs. And Donna has informed all of us that a training just launched for in-house counsels to better understand ICC's arbitration practices. The training has just been launched, and everyone is more than welcome to attend. And she has given the link that has been circulated here. There are 3 more questions, I think, which we already have answered just very quickly. Is arbitration an expensive method? Well, it depends on the time and where and how. The Arbitration Act 2001 came along 22 years ago, but there are no rules yet. I think that has been addressed in detail by Margot. And a question as why 50% of the award, a deposit of 50% of the award is not made mandatory for challenging the award and filing appeals against the award. In our legal system, doing that would be problematic. It would be tantamount to actually taking away the right to go to court. This has happened previously in other matters as well, where such a deposit, sometimes it is required, but most times we do not like to have that sort of requirement. If I may now go back to you, Claudia, and to you, Alexander, you have heard from us. Could you give us your reactions or your comments? And could you really, if you could, summarize 1 or 2 of the international best practices which would address our concerns? Who would like to go first? Claudia? Claudia?
Sure, I'm happy to jump in. Let me address a few key points and really appreciate the speakers' perspectives. So first of all, once the parties have chosen arbitration rather than litigation for kind of key reasons, which would be enforceability in a cross-border context, or flexibility of the process, or confidentiality. But really, once they've chosen arbitration, then the question is, what is the seat of the arbitration going to be? And I heard some comments about that from the panelists, and I want to emphasize this very specifically, and I know Margab made a comment as well. ICC arbitration took place in over 100 different cities around the world last year. It is not the case that ICC arbitration has to take place in Paris or London or New York. And in fact, Singapore is in the top 10 seats of ICC arbitration. The parties can select and choose the seat of arbitration. And indeed, that's what happens in most instances. When there's negotiating the arbitration clause, they're also selecting a seat as a neutral seat. And so what we're seeing, particularly, as was mentioned, in intra-Asian disputes, is Singapore or Hong Kong as the preferred seat. And it's understandable because parties want to be have an arbitration that is, in essence, connected to their region. And so we see ICC arbitrations taking place indeed in Singapore. And I would say specifically in the context of what if the parties have not chosen a seat and the ICC court is selecting and all the parties are from Asia, it would be very unusual and hard for me to imagine the ICC court picking a seat that's not in the region. So this idea somehow that ICC arbitration is taking place only in London and Paris, and that's driving costs, is actually what we would call one of the myths to debunk today. We also really should debunk the overall myth that somehow ICC arbitration is more expensive than any of the other major arbitral institutions, because we've looked at this issue and actually know it's not the case, especially when we look at institutions that use hourly rates, but even in institutions that also use a scale. It's not the case that ICC arbitration is actually more expensive. So then we look at, well, what is it that the parties are paying for? And I think that's really important because we know costs are driving decision-making, but we also know that there is a value proposition in getting an award that is actually enforceable or more likely to be enforced than others. So I want to just kind of separate out, I think, some of the discussion between the arbitral process and then what happens when the parties are going to enforce their awards, either in Bangladesh courts or otherwise. And I think it's really wonderful to hear the leadership of the Bangladesh business and legal community talking like you are now about ways in which the process in the legal structure and the courts may be able to be revised to make enforcement of arbitral awards in Bangladesh more streamlined and less cumbersome. And to the extent that the ICC can work with the community and identify the other ways in which other countries have been addressing this, or otherwise help provide strength as you're thinking about how to go about this, we'd be glad to do that. But it's really a distinct process. And I think one of the interesting pieces is we know enforcement is the driver for decision making. And so hopefully it is really a thinking about the selection of an arbitral institution that is going to make that award most enforceable. Let me just make one last comment, which is there were some comments about efficiency and online arbitration. And I just wanted to mention that with the pandemic, our practice and then our rules changed. So requests for arbitration, the actual arbitration itself, can now be filed completely electronically, even by email. So there's no need to have a certain number of hard copies. There's no need to mail hard copies to any office in other parts of the world. You literally can initiate the arbitration by email, by wire transfer for the filing fee. And then what we're seeing now with the ICC Case Connect is really to make this as online and as efficient as possible. So I'll stop there and then obviously can answer some additional questions that have arisen.
Thank you very much, Claudia. Alexander, over to you, but adding a quick question from our colleagues as to whether the ICC has ever taken it up with the government of Bangladesh about publishing rules under the Arbitration Act, or is it something that you think that you should be doing?
Thank you. Let me start by that last one. I think it's always a good opportunity to hear that the government is actually taking a much more straightforward policy with regard to the use of arbitration, not just in infrastructure, but in general, other activities in which it has to pursue, well, solicit investment and then pursue projects. I think that is, again, an area where ICC excels, and I don't want to make a comparative with other institutions. So with very few exceptions, what I will say will focus on our own experience, because I think that tells its own tale quite convincingly. 1 out of 4 cases that were administered last year under the ICC rules had a state or a state-owned entity as party. That's 25% of our cases last year. There is therefore a very clear and pronounced preference by states and SOEs worldwide in using ICC arbitration, not only in those circumstances, and the example was given, and it's a very good example, where funds are being injected into projects by multinational development banks, or only in instances where contracts will follow specific models, such as the FIDIC models, but also in instances where states are developing their own policy with regard to dispute resolution and prevention, I should say. And that is where we go back to strategy and how arbitration and dispute resolution more broadly is seen by businesses. And by that, we also mean states and SOEs as a factor of risk that needs to be taken into account, weighed against other provisions of the contract, and followed in the same way that other contractual clauses will be followed in the performance of the contract. So it's very clear, the message is very clear, and we're very happy to work with you in establishing contact with the authorities in Bangladesh, in that other states have gone down that route, and they continue to use ICC arbitration specifically for this reason. And there is a lot of experience that comes with it, because this is not novel. We started in 2012 with about 10% of parties being states and SOEs, and 10 years later, we have arrived at this figure. And this is mostly, if not almost exclusively, commercial arbitration. It's not investor-state arbitration. I don't really believe that there is another institution that actually has that record to demonstrate. But as I said, it's experience, it's not just numbers. And I will touch upon here also the comment that was made maybe once or twice on our perception of an overtly bureaucratic system. I really don't think that's fair. When you approach states, for instance, when you are administering matter involving states, there are certain aspects of case management touching upon the work of the court, the work of the secretariat, the work of the tribunal, that's sometimes required to be done differently. I can't, probably in the interest of time, I can't really expand into the details right now. But obviously, when arbitrating with states and with SOEs, certain matters need to be addressed in a different way. Having said that, if you have the experience on how to administer cases with states, then the efficiency of the process will be guaranteed, because you have done this before. You are not doing this for the first time, or only in a casual way. But I would like to expand on a couple of other things very briefly. One being the issue of cost, primarily the issue of cost, if I may. I think we heard today two different things. First, that arbitration is much costlier than state court litigation. And second, that there is a perception that ICC arbitration is generally costlier, I assume, from everything else in the world. Again, I don't think that these perceptions are correct, and we'd be very happy to work with you in spreading the word. On the first one, if one compares the absolute number, amount of money that one spends in litigation versus what one spends in arbitration, probably the figures in arbitration in some cases might be higher. But let's think, as we very often do as lawyers, as we are all lawyers coming from different jurisdictions, at what process we would be advising our clients to go into if they had to file a motion before a first instance court how much time and how that time would translate into money until they get a final judgment, an appealable judgment at the second instance, if not at the level of cassation or final appeal. So, in many jurisdictions, especially those where the court system is clogged, access to justice is seriously impeded. And to be able to actually get a final judgment on the basis of which you can collect, you need to wait for years. And that has a cost. That translates into money lost. That translates into a liability that goes onto your books year in, year out. That is something that arbitration eradicates by providing, usually, a final instance, final instance, on the basis of which you can actually proceed and get a valid and enforceable award. On the second point, we did the empirical study some years ago. If you decide to arbitrate under the ICC rules, the impact on the overall budget that a party will have in terms of legal costs, and of course the huge percentage of legal costs will be the costs of the law firm that will be hired, and of course all associated costs with that. So what is added to that is about 2%. The ICC administrative fee is at best 2% added to the overall budget. I would like to know if there is any data indicating for what the comparative costs for ad hoc or other institutional arbitrations might be at that point. And if we were to do that, then I would be able to say that we're doing an apples for apples comparative. And then we would be able to safely deduce if ICC arbitration is costlier than others or not. But beyond that, let's not also forget what this 2% gives the parties. This gives the parties supervision of the arbitration from the day the request for arbitration is filed until after the final award is rendered. And it gives access to unique services like the scrutiny of arbitral awards. Now, scrutiny is a word that is used by others. Scrutiny, however, is a service that nobody else apart from ICC offers. Scrutiny is not dotting the I's and crossing the T's or running a word processor for spell checks. Scrutiny is an exercise in ensuring that the award is valid and enforceable at law before it is rendered. It requires a body of experts providing peer-to-peer review week in, week out, all year long for all ICC arbitral awards. It requires a capacity of 195 court members, exchanging that experience and instilling it in the awards. That is not something that any other arbitral institution is in a position to provide today. So this is basically what that additional maximum 2% on the budget offers to parties using ICC arbitration over other forms of arbitration or other forms of disputes. I would probably have to stop here because I feel that I may have overextended your allocation of time, Nihad, and thank you.
No, that's perfectly fine. Thank you for elucidating all that, Alexander. But here's the thing about perception. It's very difficult to break it down. And I think we will need to have much more engagement from ICC if we are to break this perception down and make ICC the first choice, as opposed to, for example, SIAC or anybody else. Thank you all very much. Thank you to the speakers, the panelists. I will now hand over to the Secretary General of ICC Bangladesh, Mr. Rahman, for the closing stages of this discussion, which has been very, very helpful for all of us indeed. Thank you very much. Mr. Rahman.
Thank you very much, Chairman Nihad Kabir. I will not take it because we already exceeded 4 p.m. It's now 4 p.m. Everybody is waiting. So, but I would like to thank ICC Court President Claudia Salomon and ICC Court Secretary General Alexander Fessas, and Donna, of course, Juan, from joining us today, and our President, Mr. Mahbubur also has cancelled all his appointments and joined us today and stayed back to listen to this program, and also joining and sharing his views. And we have about more than 110 participants who join, including some media people. So I would like to thank all the speakers and all the participants who have joined, including the media. Thank you very much. And I would like to request Donna to say a few words on behalf of our Asia office. Thank you, Donna.
Thank you very much, Mr. Ham. I understand that my role as the last person speaking in this event is to keep my speaking short. So it's a great honor working with ICC Bangladesh on this roundtable dialogue, especially in this occasion. We build mutual understanding and trust. We resolved misunderstanding among the clients and the arbitral institutions. As Claudia highlighted that the ICC Court is the only truly international arbitral institution, this event is our commitment as an international institution to work with local colleagues, building capacity for the local arbitration community and the business community to help the companies to resolve your disputes in an efficient and economic way. More importantly, a more enforceable way. As there was a question about ICC steps to pursue the lawmaker to amend the Arbitration Act law, there was a question about this. And this is exactly our efforts to work with the local community together to make arbitration a more acceptable mechanism to help the business resolve your disputes. From any point of view, Bangladesh is one of our go-to place in Asia. Today's event is a great success. I'm so grateful for ICC Bangladesh to spend so much time and efforts on this event and make it happen. Special thanks to Atom for putting everything together. And on behalf of the ICC Court, I would like to thank all of our speakers and participants today. And thank you all very much again. Have a good day.
Thank you, all of you. Thank you. Thank you very much. Thank you. Bye-bye.